Hello everyone, welcome to Chapter 8 of CRJ 111, Police and Society. I'm Professor Steve Martin with Des Moines Area Community College Criminal Justice Program, and in this chapter we're going to talk about the legal aspects of policing, one of my favorite topics and one that we could actually spend a large amount of time talking about, and unfortunately I just have a few minutes, so let's dive into this and get going. We're going to talk about searches and seizures, the legal aspects of that, arrests. We're going to wrap up talking about the case of Miranda v. Arizona. As far as searches go, again, searches are governed by the Fourth Amendment of the U.S. Constitution, the Bill of Rights. And basically the Fourth Amendment protects citizens from unreasonable searches and seizures by government officials, and also has a requirement of probable cause to search or arrest. So we talk about this term probable cause. A lot of people have heard about it, but they don't really know what it means. And it's, to put it simply, in my opinion, it is the idea that criminal activity is occurring, has occurred, or is about to occur. And law enforcement officers have to have articulable things to point to. Specific things they can point to say why they believe that this crime has occurred. And they can obtain those beliefs from things that they observe, from information that they have received from a third party, for instance, that someone has committed a crime, or circumstantially. They might have observed a suspicious circumstance and took action based on that. For instance, an officer is on patrol at 3 o'clock in the morning and they see a car pull out of a closed business. And the officer goes ahead and stops that vehicle because they are suspicious circumstances. And it turns out that individual had just stolen something from that business or had burglarized that business. That would be an example of circumstantial probable cause. Stop and frisk. We see the police doing this all the time. And basically their ability to do that came from the U.S. Supreme Court case of Terry versus Ohio, which came down in 1961. And in that particular case, a Cleveland, Ohio police officer was on patrol, saw someone acting suspiciously outside of a business. It turned out being Mr. Terry, and he stopped Mr. Terry, patted him down, and found that he was in possession of a loaded handgun that was being carried concealed. And he went ahead and charged Mr. Terry with the crime of carrying a concealed weapon. He was convicted. Mr. Terry subsequently appealed that conviction all the way to the United States Supreme Court, and the U.S. Supreme Court ruled that under certain circumstances, the police can stop and frisk someone. They can stop and frisk someone if they are reasonably suspicious that that person is committing a crime or their criminal activity may be afoot. It doesn't rise to the same level of probable cause, but it's what we call reasonable suspicion. The officer has to point to articulable facts and circumstances based on their training and experience to believe that criminal activity may be afoot, and the stop and frisk has to be brief, and the frisk is limited to the outer clothing of the person, and the search can only be for weapons, and nothing more than that. And that again came out of the ruling of Terry versus Ohio back in 1961. As far as search and seizure goes, the courts have ruled on occasion that despite what the Fourth Amendment says, there are times when the officer may conduct a search without a warrant. And some of the more common ones would be a consent search, where somebody has waived their Fourth Amendment right by telling an officer that they can go ahead and search either them or something that they're in possession of. The thing with consent searches we're concerned about is that the consent was given voluntarily and intelligently, meaning the person voluntarily consented, wasn't in any way coerced into that consent, and that they knew that they were waiving their Fourth Amendment right. A search incident to lawful arrest is another example of when police may search someone without a warrant, and basically it's kind of self-explanatory. When the person is arrested, the police may search that person and also the area immediately around that person for contraband or weapons. Exigent circumstances would be another situation, and exigency is basically an emergency where there is a very high likelihood that evidence will be destroyed unless the officer seizes it immediately. And that's going to be maybe something in a burning building that could get destroyed, might be seized without a warrant, or maybe something being flushed down a toilet. It's possible that the police could maybe seize that item without first obtaining a warrant, but the police have to show that it was really an exigent or emergency type of situation to use that. The motor vehicle exception is another one, and this came out of the U.S. Supreme Court case of Carroll v. U.S., and that happened back in the mid-1920s, and that was actually a bootlegging case out of the state of Michigan, where the police stopped a vehicle and searched it and found alcohol within it that was being illegally transported by a couple of bootleggers. And prior to that time, the ruling was that the police had obtained search warrants to search motor vehicles. Well, with the evolving highway system in the United States and more vehicles being on the road, the Supreme Court thought it was time to answer this question. And what they said was in their ruling that because a motor vehicle is movable, is mobile, and is traveling upon a public highway, it would be impractical for the police to obtain a search warrant every time they stopped a vehicle to get a warrant, and that if the police had probable cause to stop a vehicle and then probable cause to search, that they could then do so without a warrant. And again, that was the Carroll doctrine. That was Carroll v. U.S. back in 1925. And what the courts are looking at, of course, in these cases is what is someone's level or expectation of privacy under certain circumstances. And obviously, you have the most expectation of privacy in your own home, and it kind of goes down from there. Obviously, if you're operating a motor vehicle on a public road or highway, your expectation is going to be much less in the eyes of the court. The exclusionary rule is another legal term that's used to describe the fact that if the police illegally obtain evidence or unconstitutionally obtain evidence from someone, that evidence will not be allowed at trial. It will be excluded, thus the term exclusionary rule. And this actually came out of two U.S. Supreme Court cases. The first case was 1914, Weeks v. U.S., and that was a federal law enforcement case where federal agents violated someone's civil rights, and they lost that evidence. So that's when the exclusionary rule was actually established. In 1961, in the case of Mapp v. Ohio, in this particular case, Cleveland police violated Miss Mapp's Fourth Amendment rights by searching her house without a search warrant. And the courts previously had held only in federal law enforcement matters could evidence be suppressed if it was illegally obtained. Well, in this particular case, they applied the exclusionary rule to law enforcement actions everywhere, not just federal law enforcement actions. So the exclusionary rule for the first time was applied to the states in seizing and losing evidence at trial if it was seized illegally. And so that's a little bit about the exclusionary rule. Proper procedures for making a legal arrest. The textbook talked about this a little bit. Basically, there's four main things that have to be established. That number one, the person affecting the arrest has the authority or jurisdiction to do so. Okay. There is an actual seizure that takes place, which means that the person to be arrested is seized or detained by law enforcement officers, and that the law enforcement officers communicate an intent to arrest them. For instance, you're under arrest. Would be the communication of that intent, and then the understanding by the arrestee that in fact they are under arrest. Arrest warrants and search warrants, I guess, are both obtained by the completion of an affidavit by the person, the law enforcement officer who is seeking that warrant to search or arrest someone. An affidavit is basically a legal document which states that the officer has probable cause to believe that for instance, someone is in possession of stolen property and they name that person, give an address and a location where the stolen evidence is to be located, and then they have a brief description of the circumstances surrounding the investigation and the crime. It all goes into this affidavit. It's then taken before a judge. The judge looks at the document and then decides whether or not probable cause exists to issue either the arrest warrant or the search warrant. And again, the arrest warrant is going to be for somebody based upon a crime they've allegedly committed. And again, the officer is going to delineate the probable cause for that. And a brief set of circumstances are also going to be listed in there for the judge to use to deliberate whether or not probable cause exists. And then if the judge does believe that probable cause exists, they will go ahead and issue the arrest warrant. Arrests in the United States usually are made without warrants simply because the officer did observe the action or took the word of a third party that somebody did commit a crime. And so in many cases, officers do not get arrest warrants before they arrest somebody. We're going to talk a little bit about the Fifth Amendment. And the Fifth Amendment is basically a protection that someone has to not be compelled to testify against themselves. Okay, this is called a protection against self-incrimination. And this comes into play with the Miranda warning. Basically with Miranda, this is a legal situation that came out of the case of Miranda v. Arizona, where you have somebody that is a criminal suspect. They are suspected of committing a crime, and they are in custody, and they are being subjected to interrogation by the police. And so when deciding the constitutional aspects of whether a confession was obtained or an admission given in violation of Miranda v. Arizona or some other constitutional provision, they have to weigh certain things in determining that. They have to look at whether the individual was in custody. Custody means that the person doesn't feel that they're free to leave or that they are actually free to leave at any time from this custodial situation. If they're told they can't leave, or if they're in handcuffs or things like that, the courts have pretty much said that they are in custody for the purposes of Miranda. Were their statements made voluntarily? Was there coercion involved? That type of thing. Also, were they being asked things of an incriminating nature? Were there questions designed to elicit an incriminating response? What was the line of questioning? So if they are in custody and they are being subjected to interrogation, then Miranda does apply. And basically they have to be told by a law enforcement officer that they have the right to remain silent. Anything they say can and will be used against them in the court of law. They have the right to an attorney and have that attorney present with them during questioning. And if they cannot afford to hire an attorney, one will be appointed to represent them at no cost to them. So it basically incorporates portions of the Fifth Amendment, protection against self-incrimination, and a Sixth Amendment right to legal counsel under those circumstances. A public safety exception is simply the type of exception where, let's say somebody possibly planted a bomb in a post office. And on the way out, a law enforcement officer responding to the scene catches the individual who maybe planted the bomb, stops and quickly questions them. Hey, where's this bomb at? Where did you leave it? Obviously it's a Miranda situation where they're being asked incriminating things and they're in custody because they're not free to leave, and they give an incriminating response. It's in the stall in the men's bathroom. The courts have held that this is a public safety exception because there is a definite immediate risk to the public where the police need to know that stuff. So it doesn't fall under the parameters of Miranda. Anyway, that wraps up Chapter 8, one of my favorite chapters, and I hope you enjoyed it too. If you have any questions, be sure to email me and let me know. Thanks.